Exclusively on Secular Media Network, this is the Gaytheist Manifesto.
Hello and welcome to the Gaytheist Manifesto, your source for news, commentary, discussion, and debate at the intersection of the atheist movement and the LGBT rights movement. I am your host, Callie Wright, joined by my co-host, Ari Stillman. What's up, Ari?
Yay! I am awesome.
You are.
Reasons.
You
yes.
are. You are indeed awesome for reasons.
I'm doing awesome.
Oh, you're okay.
So, if you haven't been following us on social media, you don't know anything about this, but basically some stuff happened that made our week pretty shitty, and I'm not going to get into it because by the time this episode posts, it's all going to be over and done with anyway. But so I was having a really, really crappy week, and after I got off work, I found out that some friends were mad at me, and I was really upset, and I was sitting in my car crying for like an hour and a half, and I text my partner, and I'm like, I'm going to come home, and I've been crying, like, please give me some space. I know you're going to want to, like, cuddle me and stuff, but I just really want some space. Nothing's really wrong. I'm okay. And he goes, okay, well, when you get home, there's a surprise waiting for you. I was like, okay, maybe he bought me some cake or something. And I walk in.
Cake is cool.
Yeah, cake is great. I love cake. And I walk in, and my partner Zach is sitting on the couch, and there next to him is my queer platonic partner Casey, who he had arranged a surprise visit for the last 2 weeks. They've been plotting this against me. And I just threw my stuff on the ground and burst into tears and hugged her, and it was great. So this is one of the best things about polyamory is when your partners conspire against you to make you happy.
That's amazing. I love the response that we got from last week's episode, by the way. Just throwing that out there with Kira on. Fantastic.
Yes. Oh, the most adorablest ever.
Yeah, and for those who didn't notice, I am trying out my new voice on the show, so it's not light years different. It's not exactly where I want it to be, but, you know, I'm settling in. So this week on the show, we're going to have a fun conversation about legal stuff. Our guest is Andrew Torrez, host of the Opening Arguments podcast. Welcome, sir.
Well, thank you very much for having me on the show.
Yay.
So tell us a little bit about who you are, what you do. Tell us about the show. Just give us your life story.
All right, and I will try and be super quick about that. So my name is Andrew Torrez. I am a practicing civil litigator and business attorney. I'm admitted in Maryland and D.C. If you Google for the law offices of P. Andrew Torrez, and that's Torrez with a Z, you will come up with my page. About 6 months ago, I did a guest appearance with Thomas Smith on Atheistically Speaking, and we started in that episode to talk about, it was right after the death of Antonin Scalia, so we were talking about the Supreme Court and jurisprudence and all of that, and since then, Thomas and I have done a number of Atheistically Speaking episodes together, and then we decided to collaborate on a new project which is called Opening Arguments, which hopefully will be on iTunes by the time this drops. We have recorded a number of shows, and we're just trying to make sure we hit the technical requirements and launch properly on iTunes. But the whole idea behind Opening Arguments is, as fans of this show know, I mean, Thomas is fantastic, and he's a terrific interviewer. And basically, we look at contemporary legal topics, and I delve into the history of the law behind those. And our tagline is sort of trying to give you the background that you need to discuss these issues intelligently so that you can win your arguments whenever someone is wrong on the internet.
Oh, is that perfect? I love that so much.
A worthy, noble cause, indeed.
Now, I mean, that's not to say we're completely nonpartisan. I mean, I think our political biases come through. And
that's okay, as long as you're honest about it.
Yeah, I mean, you will not find, sort of contrived arguments for, terrible positions on our show. But we try and be honest about, what the status of the law is, which, I think is important if you are, if you're going to be an agent of change, you need to know, what are you changing from, right? What is the background? What does the law currently look like? And that's what we try and do.
Yeah, fair. So I wanted to have a discussion mainly about two things, and they do sort of segue into each other, but I wanted to have a discussion from the legal point of view about, RFRA laws and this argument surrounding religious freedom. And the most recent example I can think of that is this the case with Christian Mingle, where they were forced to add same-sex dating options and allow gay people to connect with each other through the site over the objections of the founders of the website. And obviously the argument is, it's their website, it's theirs to do with what they want, free association, so on and so forth. So I would love to hear your perspective and your comment on that. And I mean, I know this kind of applies to other things as well, but that's just kind of the most recent thing that comes to mind.
Yeah. And if you can tell us why David Smalley is wrong, that would be even better.
Well, I don't know if you know this. David Smalley and I got into quite a little fight on Facebook when he posted his article on why Christian Mingle was wrong to engage in the settlement. If you'll forgive the plug, if you go to my firm webpage, which is patorrez.com, and you click on the blog section. I wrote a long post that is called Understanding the ChristianMingle.com Settlement, and I did an episode with Thomas on AS about it as well. But essentially, I mean, that story has been almost all of the reporting on that story is incorrect. Let me put it that way.
And there's a shock.
Yeah, I mean, if I can sort of hit the highlights, the biggest aspect is that what happened in California was a settlement, a voluntary settlement, right? So Christian Mingle isn't being forced to do anything. They deliberately chose to do what they chose to do.
Wow, I actually had no idea about that.
Yeah, it's kind of the big thing. And that's, that's part of what we're doing on Opening Arguments. What I try and do in my podcast appearances is say, if you begin with with a mistake about the background and governing law, you'll come up with incorrect conclusions, right? So, I've got a link on my article to a representative of Christian Mingle who said, yeah, we're really pleased with this resolution and we're happy to kind of put this behind us and move forward. So, the first premise that there's a big bad court in California that is forcing Christian Mingle to let gay people on their site, it's just not right. There was a lawsuit. There could have been court action, but eventually, and the reason that civil cases like this settle is because the parties get together and narrow the range of uncertainty about an outcome. And in this case, California has a pretty robust state equal protection statute. It is called the UNRUH Act, UNRUH. It's California Civil Code, Section 51. Rather than go to court and lose, what Christian Mingle decided to do was resolve the case amicably by adding some code to their website. And as far as I can tell, after kind of the initial flurry, everybody seems pretty happy with it. So, which is, you like to see that kind of outcome in the law as opposed to, a situation where there's a one-sided victory and, somebody's crushed into submission or something like that.
For sure. Well, and what that brings to mind is if memory serves, this was also an issue with, what's the other dating site? The one that makes you take the silly survey.
Yeah,
yeah, there was
eHarmony. Yeah, there was an issue with them because they basically claimed the same thing because there were no options for same-sex dating on the site, and my understanding was that it was legal action that forced them into doing that. Is that accurate?
And Callie, you are exactly right that there was a settlement just like this 6.5 years ago with eHarmony, and they did the exact same thing, which is to say they made a few small changes to their website in order to comply with the robust California Civil Rights Act. But again, that was not an example of the court forcing them to do anything. It was an example of a voluntary legal settlement in light of the operative law. Now, again, I don't want to go too far and suggest that the settlement did not have some implicit coercion behind it, because it did.
Right, yeah, that's what I was going to say. Because people on the other side of it are going to say, like, well, it was only voluntary because they had that threat hanging over their head.
That's true, and I want to be as fair as I can to that argument. But what I saw, and particularly what I saw from the David Smalley post, was sort of a slippery slope parade of horribles that says, once the court can force Christian Mingle to do this, they can force anybody to do anything, and they'll force me to do podcasts that are pro-Christian, and leaving aside kind of the logic of the slippery slope on that, which I don't know, we could get into, but I want to talk about the law because that's my area of expertise. Yeah. A settlement has no binding legal authority on the person that comes next. And the reason for that is that once the parties get together, you can settle on any sort of terms that you want. So, for example, I tend to represent businesses in commercial disputes. And I had a dispute once that involved an employee who went off, who was hired as a high-level executive to help grow the business in the Midwest. And the business checked in on him after about a year, and their numbers in the Midwest hadn't moved a whole lot. And so they did some digging, and they realized that what this employee did was went out in the Midwest office and essentially used company resources to develop his own competing business, and started diverting company customers, to his new business. And so obviously, I was brought in to try and extricate this person, who was a highly paid executive from the company. And all of that is to say, one of the things that held up, we agreed on economic terms, but one of the things that held up our settlement for 3 months was the employee was demanding an apology from the CEO of the company, who was my client. And my client was not willing to give that to him. And so,
gee, I wonder why.
Well, and we eventually held out, and ultimately they took our offer minus the apology. But the point there is, suppose we'd caved and given them the apology, right? That would not be binding. That would not say, like, the next time you sue somebody for corporate misappropriation of assets, that they have to give a public apology, right? Like, the terms of that settlement apply only to the people.
Right. So it's not precedent setting. Exactly right. And so all of the arguments saying this is going to form a terrible precedent and this and that are, again, in my view, I don't want to suggest that there's zero merit to the other side, because there is some pressure from the understanding of how the laws operate. But to take the terms and extrapolate outward is just, right, it's something no lawyer would do. And I thought that there was an awful lot of kind of arguing back and forth about, this is the end of Western civilization, and nobody participating in the arguments had a law degree. And so I kind of perhaps foolishly waded in and said, well, if you want to ask somebody with a law degree, like this is what the actual consequences of a settlement are. Right. Well, and so let's be fair, because and let's state the position, which to be honest, there's part of me that is sympathetic to. Mm-hmm. So David's position was that he had, I forget who, but like a Christian mega preacher reach out to him to do voiceover work, and he turned them down because he didn't want to participate in a thing like that. And in his mind, what this does is it sets a precedent for saying that he's now not allowed to say no to those things. And I mean, immediately in my mind, I think those aren't equivalent. Like, even if those things were precedent setting, those decisions were precedent setting and legally binding, I'm not sure that those situations are similar enough to apply. But can you talk about why that doesn't hold weight with you?
Yeah, because what you need to do is look at the particular law or laws that are in effect when you're talking about what you're going to be compelled to do, right? Like, if I sue you, I have to cite the provision of code that is either a state law or a federal law that says why I can sue you and what my remedies are. And if I can't cite that, then I have no case, right? We don't have sort of, I can't say Kelly makes me feel bad. Not that you do, but and take you to
Allegedly.
court and seek damages. Right.
Right.
I've got to, you have to engage in conduct that is a civil wrong, which and so the particular statute that's at issue here is California Civil Code Section 51. It's called the UNRRA Act after Jesse Unruh, who's a prominent California politician that pushed this law through. And the UNRRA Act was really one of the forerunners of state equal protection laws in the country. And so what it says is, and let me get to the sort of relevant section, which says all persons within the jurisdiction of the state are free and equal, and no matter what their sex, race, color, religion, ancestry, national origin, disability, medical condition, genetic information, marital status, sexual orientation, citizenship, primary language, or immigration status, are entitled to the full and equal accommodations, advantages, facilities, privileges, or services in all business establishments of any kind whatsoever. Okay, and that is, you'll notice a couple of things about this provision. The first is there's a very long list of protected classes, and that exceeds the kind of protected classes that exist under federal law under Title VII of the Civil Rights Act of 1964. So California has kind of gone above and beyond federal law and said we want to protect minorities that include all of these classes. And in particular, the two that come into play in the Christian Mingle case are sex and sexual orientation. And the way in which you go about applying that is saying, have you provided full and equal accommodations? Or have you provided, if you provide so that's the first test, right? Are you providing full and equal accommodations to everyone? If you are, then great, you've complied with the law, go ahead. If you're providing unequal accommodations, then you have to ask, on what basis are you providing unequal accommodations, right? And this is sort of striking the balance between the libertarian notion of I can do whatever I want with my business, and if I don't want you, on my property, get out, right? Which is, to be fair, there's a degree of that. In our history, and I think that underlying premise of freedom is important to our economy and to our politics and to our history. But that's tempered, right? I mean, if you think about the initial Civil Rights Act of 1964, the libertarian answer was the defense of segregated lunch counters in the American South, right? It was, right. I own this restaurant, and if I don't want black people in my restaurant, then black people need to get out of my restaurant, right? And what we as a society decided was we're going to restrain that libertarian impulse where it conflicts with minority groups that have had a history of discrimination. Because there's some ways in which we think it's perfectly reasonable to discriminate. Let me give you an example. If I run a restaurant, a lunch counter, I am going to discriminate between those who have the ability to pay me and those who do not. Right. And I will offer unequal services. If I'm selling a hamburger for $7, if you have $7, you can buy my hamburger. If you don't have $7, you got to get out. And so obviously in that sense, you would not want to have, complete economic inequality be a reason for a protected class that prohibited discrimination, because you want to allow people to sell things to people who can afford it and people who can't.
Right.
But you don't want people to be able to systematically exclude members of minorities, particularly those that have been subject to historical discrimination. And that's why statutes like this take the form that they do, right? Which is to say, you have a general promise of equal access, and then you list your protected classes, and what you have to do to raise a claim under this law is show that you're a member of that protected class and show that your equal accommodations, advantages, facilities, privileges, or services were denied. And here, it's really, really simple, right? With the Christian Mingle case, it was really, really simple, which is to say, if I'm a man and I log on to the site and I say, provide me information about women who would like to have a relationship with me, it would do it. But if I was a woman and I logged onto the site and I asked it the exact same question, it would refuse to do that, right? And so that's a pretty clear, I mean, that it's just about as clear as you get that you were offering a different service to men than you were offering to women. And in California, it's just crystal clear that the law prohibits that. In fact, one might even argue that the California law goes too far. One of the cases that I talk about in my article is it's like a 1970 case in which a man sued a California bar for having ladies' night, right? And you can see how the same logic applies. They were like, my beer costs $2, but the same beer to somebody who's a woman costs $1, and you're providing the same service, but price discrimination on the basis of gender. And the California court said, yep, that's right, and struck it down. And so, if you want to argue that the California statute goes too far, I think that's the best argument to start with, right? I mean, I don't know that I agree with you that it would go too far, but charitably, right? Like that's where you should start. You should say, hey, if I got a bar and I want to have ladies' night, let me have ladies' night, right? Like this is not an example of something where the law needs to intervene and sort of stop that libertarian impulse. But I think the counter argument to that is people in California, right? It's been a decision in California that's been valid for 35 years, and people seem to be doing just fine, and bars in California seem to be doing okay. And if there was any kind of great public outcry, you could just amend the UNRRA Act, and add in a clause that says, okay, we're not talking about ladies' night, just kidding, right?
Right.
And everything would be fine. And the fact that people haven't done that is a suggestion that the court did okay in that case.
Right.
So
and I don't want to I don't want to keep picking on David, because I want to make it clear that I love David to death. I don't agree with him on this issue, but I love David to death. He's a great friend. So let's talk about the specific example that he gave about a Christian organization coming to him and saying, I want to hire you for voiceover work, and he says no, specifically because he doesn't want to participate in that sort of thing. Could they then claim religious discrimination in that case?
And I just think it's totally disanalogous, because on the merits of that argument, you're not talking about failing to provide a different service, right? Like David has. What he's not doing is, restricting a database of names or something like that. His service is if you want me to engage in providing X kind of content, right? Talk to me and we'll find out if that's the kind of content that I do. And so, I just don't see, right? Like that's why I went through the statute. You have to run it through the statute and say, if you came to David and said, I want you to read this piece of text, right? David would have the same response regardless of what your religious belief is, right? And so that's really the area of analysis that is implicated here, right? So let me give you an example. It's perfectly reasonable for David as a voiceover talent or as a podcaster to say, I am not going to read something hateful and sexist. I'm not going to read that, right? And it's perfectly reasonable for him to do that because he's not discriminating against the person that's coming to him. He's exercising his judgment based on the content of what it is, right? So if a man came to you and said, I want you to read this sexist statement on the air, you'd be like, no, go away. If a woman did, no, go away. If, a gay person did, if a straight person did, if a black person did, if a white person did, he's treating everyone equally in refusing to air, homophobic or awful content.
Gotcha.
And
that makes sense.
And to me, that's the real distinction, right? Like he doesn't have a business right now of airing hateful statements on the air. And so
Right.
there's no, for the most part. And so there's no real claim that somebody can say you're discriminating against me as an individual. You would do this exact same thing if only I were X, right? Like, and that's kind of at the heart of an equal protection claim. And the Christian Mingle is a totally different case, right? Like you're saying, this is what you do. You are providing a list of, single men who would like to be in relationships. And if I'm a woman, I can request that. And if I'm a man, I can't. What the hell is your justification for that?
Okay.
And the justification is, well, my sincerely held religious belief, blah, 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 blah. And California says, well, that's not good enough, right?
So the distinction, I want to make sure that I'm understanding this clearly. So the distinction is that if I'm going to provide a service to a man, I have to provide a service to a woman, or that similar service to a woman as well, or to a Christian person, to a Jewish person, so on and so forth. The difference is if I refuse to do something because of a specific thing about that person. So so let me apply this sort of to a different area, because the analogous thing there for me would be like let's take the argument of bakers not wanting to bake cakes for gay weddings, right? So to me, applying that line of reasoning, and I'm not a law degree, you can tell me if I'm wrong. To me, applying that reasoning would say that a baker, if they're going to bake a cake with purple frosting for one person, they have to be able to bake a cake with purple frosting to another person. But what they might object to is, doing something creative, putting art on the cake or writing something on a cake that would be a tacit endorsement of homosexuality or, anything that they disagree with. And to my understanding, the law thus far has not made that distinction. Is it following that same line of logic? It's I'm not doing this to you because you're gay, when some might even say that, if you want a yellow cake with mint frosting, that's fine. I'll sell that to anyone, but I'm not going to sell you a cake that says "Happy Gay Wedding."
Yeah, and I think so. There are a number of things to unpack there, but I think you've analyzed it exactly perfectly. And I'm not just saying that to be nice because I'm on your show. So the first thing that I want to set aside is remember that these baker cases are often, in fact, all of them have been in states that aren't California. And so there's states that have a less robust state equal protection law are going to analyze the issue differently. Okay, so we shouldn't be surprised that there hasn't been a uniform set of results, because a lot of states lag behind California in terms of protecting on the basis of sexual orientation. So that's the first thing. Like, you just can't look at what happens because different states have different laws. And California is at the forefront of having a robust equal protection law, and many states are, obviously, if they're at the forefront, everyone else is behind them. So that's number one to keep in mind. Number two, I think you've analyzed it perfectly, though, in the sense that you ask, what business are you in? I'm in the business of selling cakes that say, congratulations on your wedding, right? So I've got to sell a cake that says, congratulations on your wedding to straight couple, gay couple, whatever, assuming that the state law protects on the basis of sexual orientation. If it doesn't, I can discriminate against gay people, and that's wrong. And those are the kinds of states where we should be organizing and trying to change the law. But if you have a California-like statute and it's illegal to discriminate on the basis of sexual orientation, then I've got to sell you that cake regardless of whether you're straight or gay and regardless of what my personal feelings are about it. But when the gay couple comes in and says, we want you to write in purple frosting, to the most blessed union of the, something, I'm not going to try and come up with an example, but a pro-gay message, right? You could say, well, I'm not going to write a specific pro-gay message. I'm not going to go above and beyond what I do for the rest of my customers, right? You can have the same service that anybody gets. And I agree that's kind of a fuzzy line. And I also agree that not all the cases have been analyzed that way. But it seems to me that that's the right that's the right dividing line that protects. I mean, you should go back to the principles that I described in the beginning. It protects your libertarian freedom of, I don't want to force the government to force you to articulate a public ideology that you disagree with. And I wouldn't want Christian bakers to have to write, I love gay marriage on a cake, right? Because they don't,
Right.
But if they sell a cake that says, I mean, there was a recent, there was another recent bakery cake. I think it was a bakery example where the couple had requested a cake or cookies or something, and then the baker actually went out on Facebook and stalked the couple.
Yeah,
and it wasn't even for a wedding; it was for one of their birthdays.
Right? Yeah.
And they published the couple's address. And that was the whole thing that got missed in that entire case is they ended up winning a pretty significant lawsuit against the place
because of the invasion of privacy.
And it had so little to do with the fact that they were refused service and so much of the fact that they published their home address that got them death threats and hate mail and everything.
But again, I mean, to me, that seems like a pretty reasonable dividing line, right? Like that conduct falls on the other side of the line. Like if I go into a business and they were perfectly happy to hand me the box of cookies or the birthday cake or whatever, but then because the owner is some sort of lunatic who looks me up on Facebook and is like, oh, you're gay, or you're an atheist or whatever, and so now I'm not going to sell you the cake I was going to sell you 2 hours ago, right? Like that's where anti-discrimination clauses kick in. Does that make sense?
Yeah, that actually makes perfect sense. That really kind of clarifies it for me because there was a part of me that almost I kind of felt like a bad activist for thinking that, but I'm thinking because what I don't want to do is force a black cake maker to make something for the KKK.
Right.
You know what I mean? I want to make sure that we're not going so far that that's the corner we paint ourselves into. And I think what you said there makes perfect sense. It's how we protect those legitimate freedoms that we value, even for, the freedom for people to do things that we disagree with or that we think are even, abhorrent, while protecting our own right to free movement and free access to society. I think that makes sense.
I mean, in that case, right, if your business is, your KK cakes or something, and your business is, putting horrible, awful symbols on your cake, then the question is, are you willing to sell that cake to anybody who comes in? Right. But I agree with you. I wouldn't patronize that store,
right.
But we don't want to have an overbearing government to the point that says, you can't sell that. And obviously, I picked a ridiculous example, but real world examples are not far behind. Right. You look at some of the secondary Trump memorabilia that's out there at his rallies, and and it's not far behind. Hi, I have my business is swastika themed cakes or something like that. And that's sort of the balance of freedom of speech on the one hand, and equal accommodation to people who want to patronize your business on the other. I would point out something that kind of got lost. Before we move on from Christian Mingle, because I think we've beat that into the ground. But something that gets lost is Christian Mingle took steps to make sure that their service was not discriminating on the basis of religion either. Right. So prior to this lawsuit, you can sign up. Any of us can sign up for Christian Mingle and check the box that says atheist. I
actually did not know that.
Yeah, and again, it's the same thing, right? Because they're providing a service, and they knew, right? This is not an overbearing government. Like when they launched, they knew, well, gosh, even though we're going to be targeting Christians, we have to provide, if for some reason, there are hardcore atheists or Buddhists or whatever who want to meet Christians.
An atheist with a Christian fetish.
Yeah, exactly. we can't discriminate. We can't say, oh no, I've got this list of, single men, but I'm not going to give it to you if you're an atheist. And they recognize that. And so, they say in their terms of service, you can be any religion and come on Christian Mingle, although, our community is designed to appeal to people who are Christians, blah, 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 blah. And again, that it just seems like intuitively that that's the right kind of happy, peaceful way to resolve this in society. Make the service available to everybody. I got it, again, without, getting into atheists with Christian fetishes or what have you, very few non-Christians are going to want to be on ChristianMingle.com. But if they want to be, let them come on.
Yeah,
I think that makes perfect sense, because I think a lot of the pushback against this Christian Mingle thing was people worrying that, that religious organizations would have to start, going against their religious beliefs and start, participating in things that they didn't necessarily agree with. But I guess Christian Mingle isn't even a Christian organization. It's a business that has kind of a religious angle to it.
Yeah, well, and, sadly, recent Supreme Court decisions have really blurred that line, which used to be a much clearer line, right? I mean, you think about the Hobby Lobby decision. I mean, prior to 2014, articulating in public that your business had a sincerely held religious belief, it was something that literally would have made no sense to anybody who was aware. Businesses don't have beliefs; they're profit centers, right? But apparently now they are.
Right.
Today in school, I learned a lot. In chemistry, I learned that no one likes me. In English, I learned that I'm disgusting. And in physics, I learned that I'm a loser.
Today in school, I learned that I'm ugly and useless. And in gym, I learned that I'm pathetic and a joke. In history, I learned that I'm trash.
Today in school, I learned that I have no friends. In English, I learned that I make people sick. And at lunch, I learned that I sit on my own because I smell. In chemistry, I learned that no one likes me.
In biology, I learned that I'm fat and stupid. And in math, I learned that I'm trash.
The only thing I didn't learn in school today?
The only thing I didn't learn today?
The only thing I didn't learn
is why no one ever helps.
Kids witness bullying every day. They want to help, but they don't know how. Teach them how to stop bullying and be more than a bystander at stopbullying.gov.
Hi, this is Trav Mamone of the By Any Means podcast. The By Any Means podcast is a weekly show where I interview guests about the intersections of social justice and humanism. Just go to www.byanymeans.com, that's by spelled B-I, to hear the podcast and read the blog. Because, hey, aren't we all a little bi-curious?
The staff of Secular Coalition for America lobbies U.S. Congress on issues of separation of church and state, and they've become a powerhouse for change in the United States government. You'll definitely want to subscribe to receive their email action alerts. These are updates for important issues and ones that you can get involved with directly. And hopefully, you'll consider making a contribution to the Secular Coalition for America to help them continue fighting for your equality. You can do it all at secular.org.
Before we jump back into the show, it's time to thank our patrons. Big shout out this week to Nate. Thank you so much for contributing to the show financially and for believing in us enough to support our mission to smuggle penises into women's restrooms and to force every American into their very own mandatory gay marriage. To find out more, head over to patreon.com/thegaytheist manifesto. Thank you. Something else that I wanted to talk about, we've talked a lot about sort of public sphere discrimination, but I'm also interested in hearing about the legalities surrounding, other types of discrimination. So discrimination in employment, discrimination in housing, and those kinds of things. And it's really interesting to read about these things sometimes because, there are some places that have, they have for employment and for housing and for public accommodations of all kinds, they have sexual orientation, gender identity, gender expression as part of their protected classes. But,
favorite part of living in Illinois.
Right. Well, and actually in northern Kentucky, where I live now, in the specific city that I live in, like that's part of it, which is weird. But what I hear oftentimes, and I'm not sure where the line gets drawn in this, because I say that to people and I'm like, there are so many places in the country where I'm not a member of a protected class, where it would actually be perfectly legal for my boss to point at my face and say, I don't like that you're trans, you're fired, and I have no recourse for that. And what I've had thrown back at me is that they've continuously I think it's the EEOC has continuously interpreted Title IX as covering gender identity as part of sex discrimination, so that I am actually technically protected there. So can you kind of go into the sort of specifics about what that means and what that doesn't mean?
Sure, and there's an awful lot there. So let me go back and kind of set the legal landscape. When you live anywhere, you are subject to 3 overlapping sets of laws. There are local laws in the city or county in which you reside. There are the state laws in the state, and there are the federal laws. And one of the things that lawyers like me have to do on a pretty frequent basis is litigate where there are conflicts or gaps between those 3 differing layers. Interlocking layers. So in the area of employment discrimination, what sets and I don't want to get into the law geekery of which one takes precedence and whatever. It's not always as simple as, you might think, well, federal always trumps state and state always trumps local, but that's not always the case. In employment discrimination, what is the case is that the Civil Rights Act of 1964 and Title VII protects everybody, regardless of where you live, with a floor of a certain level of protection against discrimination in employment. And Callie, you are, and so from that floor, which protects discrimination on the basis of sex, on the basis of age, on the basis of religious identification, and a couple of other protected classes. From that floor, different states and localities can add additional protections for employment discrimination. And I should take a step back and say, in the absence of a statute, by and large, what we have in this country is the notion of employment at will, which is to say, I have a company, I hire you, I don't like the way this is working out, I can fire you for any reason, and I don't have to give an explanation, and I'm free to go contract with somebody else after that. And that, sort of harkens back to that, libertarian versus equal protection dichotomy that we talked about. You can understand why that baseline rule is in place, right? We want to protect, as a general principle, I start a company, it's my money, I can hire whoever I want. But we temper that with the knowledge of history, where we as a society have come together and said, well, you know what, when we do that and there are no restrictions, we find out that certain people get systematically discriminated against. And so we want to curtail that and say, you can hire and fire whomever you want unless you're behaving in a way that is systematically discriminating against people who have been historically discriminated against. And that's when protected classes get added to a statute. And the cost is, you're now making it, you're interfering with the business's freedom to hire whomever they want, but you're protecting the larger society against institutionalized and systematic racism. And this, I think you made this point a couple of episodes ago, and I know you made it online, Ari. But one of the aspects of these kinds of laws is sort of getting around the intent problem. Right. And that is, systematic racism is something where or systematic discrimination is something where we don't ask, are you intending not to hire black people? Are you intending not to hire gay people or trans people? We just look at it and say, well, your pattern, your behavior seems to indicate that you're not. And that's a problem. And it's a problem whether you think you're doing it or not. So that's the legal landscape. That's the question. And Callie, you are absolutely correct that that there are 20 states that have added sexual orientation, and a subset of those, I don't know which of the 20 have as a subset. It's most of them, it may be all, have added the classification for individuals who identify as transgender or genderqueer. But in the other 30 states, there's no explicit protection for those people. And the law has been, up until very, very recently, that your boss can say to you, you're gay, I don't like gay people, I am firing you. And it goes back to and assuming that you don't have a special provision in your contract that prevents them from firing you, that's perfectly legitimate. It goes back to the employment at will.
So even though the Civil Rights Act has been sort of interpreted, or maybe it's the 14th Amendment, I don't know. It's been interpreted to cover things like sexual orientation and gender identity. Even though those things aren't specifically called out, those things don't apply in most of those situations, right?
Well, and let me be careful here and answer that very, very specifically. And first, I want to say I usually give the disclaimer at the beginning of the podcast, and I should have done so here. We're discussing this for political and entertainment purposes, and nothing that I say on this podcast should be construed as creating an attorney-client relationship or as being legal advice. And I mean that really sincerely. I mean, that's not just a standard disclaimer. If you're trying to apply kind of the general principles that I'm talking about to your specific situation, you should contact a lawyer, and you shouldn't act on what I'm saying.
Yeah, for sure. Mainly what I'm trying to do here is kind of arm people who are arguing about these things, because what you hear so often is like you're arguing like, no, this is a problem, and they're like, no, it's not actually a problem because this, and I would love to be able to come back.
If you didn't want to be discriminated against, maybe you shouldn't have been a class of people that's discriminated against. Come on.
Right, exactly.
Just stop being gay. It's easy.
Yeah. So here's the situation. There have been a handful of courts that have interpreted Title VII's prohibition on discrimination on the basis of sex as applying for sexual orientation. But the announcement, the way, but that has been kind of a patchwork, right? It's been no guarantee that that another court is going to follow those previous court rulings. So there was a major announcement just about a month ago from the EEOC that said that as an agency, they were going to take the position going forward that Title VII prohibits employment discrimination on the basis of gender identity and sexual orientation. And that is a radical change. As soon as it came down, I tweeted about it from my law account. There's not been a lot written about it, but the agency has not taken that position prior to a month ago. If there were to be a change, there will be a change in the presidency. A subsequent administration could come in and appoint a new head of the EEOC, and they could reverse that policy. Okay, so
4 more years. 4 more years.
So it's an executive agency taking that position is certainly an area where the Obama administration has, been on the side of LGBTQ rights in a way that and has proactively done things behind the scenes that are not really obvious from a PR, right? Like this EEOC rulemaking got very, very little attention. It was not a PR stunt. It was not, the subject of, putting the White House in rainbow colors or whatever. It's just clearly, something that the folks that Obama has appointed to the EEOC and his administration, clearly think that the logic should extend in this direction. But it's different from being protected by a law. And so one of the laws that gets passed in pretty much every Senate, except for the past year, is called ENDA, E-N-D-A, the Employment Non-Discrimination Act. And what that would do in various forms is amend Title VII to add sexual orientation to the list of protected classes. And once that passes, if that passes, then you will have a federal protection in law that sets a floor in every state. But until that passes, you're sort of left with what is the court's interpretation? How did the agency come out? Is there going to be a subsequent administration that overrules that directive? I mean, I feel like we're making progress in the right direction, but I think that it's important to understand for the ENDA debate, right? There's certainly there were people who argued against the passage of ENDA on the basis that it wasn't necessary. And I would argue very strenuously that it is necessary. And I can talk a little bit about which courts are bound to follow which other decisions if you want. It's a little bit technical, but it's part of why the fact that you may see really great news from one case, but it might not be binding on the next court to consider it. Well, so I don't know if you want me to talk about that.
Well, and that's kind of what I respond to people is, first of all, it's a crapshoot, right? Because first of all, you have to recognize that, by and large, queer and trans people don't have the money to hire good attorneys. And you have to get into the right court in front of the right judge who's going to agree with that particular interpretation of the law because it's not explicit. It's this thing that protects people, and you have a certain group of people saying, well, we're gonna argue that this is inclusive of these people, and there's an entirely other subset of people who say, well, we're gonna argue that it doesn't, and because the law is not explicit, it just kind of depends on where you end up as to what the results you're gonna get are. Is that kind of a good way of stating it?
That's exactly right, and let me expand that out a little bit. So the way our federal courts work is in every state there are one or more federal United States District Court for the District of Maryland, for the Eastern District of Ohio or whatever. Those federal district courts are then organized into judicial circuits, and then the circuits are subject to the Supreme Court. So if you're a judge in the Eastern District of Kentucky, you are bound to follow the circuit for Kentucky. Kentucky goes to the Sixth Circuit Court of Appeals. So any decision by the Sixth Circuit Court of Appeals or by the U.S. Supreme Court is binding on a court in Kentucky. But any decision from any other circuit, and there are 10 other circuits, is not binding. And any decision from a judge, a judge in Maryland says, we interpret this federal law as protecting on the basis of sexual orientation. A judge in Kentucky can, and in fact it is common for district court opinions in federal court to say, you just have a citation that is but C, right? And you say but right. C, Smith v. Brown, D. Maryland, and you just say, Maryland, we realize, this one judge in Maryland came to a different result, doesn't stop us. So as of right now, courts in the first, fourth, sixth, ninth, and 11th circuits have interpreted some aspect of Title VII as covering sexual orientation. If you are not in a state that's covered by those circuit courts, then there's been no ruling that is binding.
Right. America, land of the free. Some restrictions apply.
Exactly.
Yeah.
Exactly.
So there's some weight of precedent, but there's nothing that's binding.
Yeah, there's nothing from the Supreme Court, and there's nothing in those other 6 circuits that haven't weighed in on the issue, or and I say haven't weighed in. Some have come out the other way. So that was your first point on it's kind of a crapshoot with the judge, which is absolutely correct. And your second, I think, is a really, really good point in talking about bringing a lawsuit, because the reality of the situation is that where most of the social change comes from comes from what the understanding is from the perspective of the employer and the HR department and the conduct that pervades the company. And so every HR manager knows that that Title VII prohibits discrimination on the basis of race, right? And so when you're setting policies for the organization, they are 100%, any HR manager who's ever had the job before, is 100% on the lookout for how are we treating our African American employees, because they know that they can be sued. They know that that's a potential liability. They know they'll lose their job. It's just a settled question, right? But if they're not thinking about it on the basis of individuals on the basis of sexual orientation, gay individuals or transgendered individuals, when they set their policies, then you might be treated differently in the workplace, regardless of what a court might hypothetically decide if you were to bring a lawsuit, right? The conduct comes as a result of people knowing and being aware and setting their policies to track the law. And when the law is in a state of flux, when the law is, the way it is right now, where there are uncertainties, then employers don't know what to tell their HR departments and don't know what to tell their managers. And that's another advantage to passing a statute like ENDA rather than, hoping the courts are going to come along and get it right.
Well, right. And I think that's a perfect argument when people bring up the fact that laws don't change culture. And, in my mind, in a lot of ways, they do. I mean, because it's kind of a statement of what we are and aren't going to accept as a society. But I think that's sort of a really good practical example of how, regardless of people's attitudes, when a law like that gets passed, I mean, obviously, there are people who are going to do what they're going to do regardless of what the law says. But generally speaking, they're going to know, like, oh, okay, well, this is a thing I got to do now. Companies that are doing it now are doing it just because, maybe they see the writing on the wall, or maybe that's, they just genuinely do value that kind of diversity. But at this point, it's their choice whether to do it or not.
Yeah, that's right. And look, do we look to law for social change is it's actually a topic we're going to discuss on a long episode of Opening Arguments. It's on our whiteboard. But I would point out, and so there are arguments on both sides, and I totally get the people who say, we want to persuade people so that change comes about organically from the bottom up. I understand that. But I think the flip side is you can look to actual social science research with things that were considered really, really intrusive behaviors. And the two studies that I know of there was a study on seatbelts and there was a study on motorcycle helmets. And basically, neither of you are probably old enough to remember back when we didn't have seatbelt laws. But
I was very, very young, and I remember there being the argument, and I just remember thinking to myself, like, why? I don't understand why people are arguing over this.
Because my freedoms, Callie, my freedoms.
Yeah, no, but it was a real argument. I grew up, and in the 1980s, you would just get in the car, like the front seat of my dad's Oldsmobile Delta 88 was a bench seat, and I don't think there were ever any seatbelts in it. It was just, it was part of the culture that, you didn't wear your seatbelt. And then they passed laws. Now I believe there are laws in all 50 states. And what they discovered was not just that people complied with the law to avoid the penalties. Because even today, right, the penalty, if you're pulled over by a police officer for not wearing your seatbelt, in Maryland, I think it's a $25 ticket, right? It's literally the best interaction with a traffic cop that you can possibly have in the state.
Right.
They found that they did follow up longitudinal interviews, and they found that people's ideas and behavior changed. And so even when there was no longer a prohibition, that people would start buckling up when they got in the car. And the same thing was true on motorcycle helmets. People who went to the mat to defend their freedom to not wear a helmet after the law was in place for a while, started habitually wearing helmets, and even when the strictures were removed, would continue to engage in that behavior because, once you've normalized that behavior and you're used to wearing a seatbelt and you understand the reasons behind it, you're like, oh yeah, well, I'm going to continue to wear this seatbelt now because, it would be ridiculous for me to have a short 30-mile-an-hour collision and catapult my child through the front windshield, And so I think that research is really interesting in terms of the power of law to change minds when, you have an initial resistance to something, and then you realize upon later exposure, like, oh, hey, this isn't so bad. Like, it's not a big deal to put the seatbelt on when I get in the car, and seems like it's saving lives. And we could talk about this in a number of ways, right? Like, think about how our culture has changed on, drinking and driving and that sort of thing. I mean, again, this, even I'm a little too young for that. But, we had a culture in the 1970s of, give me one for the road, and I'm just going to grab a beer and drive around with a beer in one hand and my hand on the wheel in the other. And we've really completely changed that mindset, and it started with a change in the law.
So what you're saying is that my plan to make it illegal to use the wrong pronouns for someone and punish it by death, and also force everyone into a same-sex marriage, is actually a great social idea?
Yeah. No,
yes.
no, I'm not endorsing that. I think that the component comes from where you have the cognitive dissonance of I strongly feel that this is an intrusion upon my freedom, but I've never tried the opposite. Right? I've never really kind of thought through the implications. It just seems like something that makes me mad.
Exactly. That's exactly what I was going to say, because just thinking this through, and I actually wasn't aware that there had been social science research done on that. I think
There's
it should be
social science research done on everything.
Well,
Callie.
right. Well, that's what I was thinking.
It's
it's probably silly of me to not have thought of that. But I mean, just thinking about it practically, right? So, like, take the Civil Rights Act, for example. I mean, there are libertarians who still today say that was an overreach. And in my mind, what I'm thinking is all of those people who just hated black people so much, and they were just legitimately afraid that the world was going to come apart at the seams if white people and black people had to mix. Once they were forced into doing it, and they realized that didn't happen, I can't imagine that doesn't have some effect on your thinking. And there's obviously the argument to be made that we don't want to restrict people's personal freedoms in that way so far in the right of, free association and who you choose to have in your life. And obviously we're not talking about making you let people you don't like into your house. I mean, we're talking, in terms of, being a business or, being a place of public accommodation. But I have to imagine that if you're forced into a situation where you're interacting with these people, obviously that's not going to change everyone's mind, but I feel like there has to be an element of that as you come to realize over time, like, wow, you know what? These actually are just people, and they have families, and they have dreams and hopes, and they have jobs, and they so on and so forth. Maybe we're not so different. Like, I can't imagine that doesn't change
You're such
lives.
an SJW.
God, I know.
Take your feelings and shove them.
Yeah, no, I mean, I think that's... it would be hard for me to imagine somebody arguing the opposite of that, right? I mean, you could encapsulate this down as the, Dick Cheney has a lesbian daughter argument, right? Like, and sure, I mean, like Dick Cheney, who's at a zero on progressive issues for his entire life, is like, well, turns out I'm okay with gay marriage. Why? Because I have a lesbian daughter. It's just and now I've had lesbians in my house for Thanksgiving, and I realize they're not part of a secret coven designed to overthrow America. Like,
they were just good at keeping the secret, is all.
Yeah.
So yeah, I mean, I it would be very, very hard to argue the contrary of that. I think the question comes in, to what extent you want to use the levers of government to force that integration. But I would point out anybody, I mean, if you're having arguments with libertarian friends who think that the Civil Rights Act of 1964 goes too far, that's about as settled a question in American jurisprudence as we can possibly get. And I don't know if you remember or read about in school the nomination of Robert Bork to the Supreme Court, but he was, the archetype of the Antonin Scalia mindset on jurisprudence. I mean, he wrote a number of books that sort of set forth the arch-conservative activist legal philosophy. And even Bork was sort of forced to say in 1986, like, I had some negative things to say about the Civil Rights Act from a jurisprudential standpoint, but it's clear that this reflects society coming together and that we're all better off for it. You will not find a voice, no matter how conservative, if Scalia were still alive, if you ask Alito, you will not find a mainstream conservative legal theorist who says the Civil Rights Act of 1964 is an overreach, or Brown versus Board of Education was wrongly decided, or anything like that.
Translation, nanny nanny boo boo, stick your head in doo doo.
Well, Andrew, I am super bummed, but we are out of time here.
No, I was learning.
We could do this for days.
Callie's against education.
I've really enjoyed being on the show. I did warn you that I tend to be verbose, so hopefully.
Listen, I give the same warning to people when I'm on their shows. I'm like, you're going to ask me a question that consists of like a 5-word sentence, and I'm probably going to spend at least 5 minutes answering it.
Tell a story now.
Right. So before we go, why don't you just tell us where we can find all of the stuff about the podcast? If we want to get in contact with you, how do we do all that?
Yeah, it is. It's the Opening Arguments podcast. You can email me at openarguments@gmail.com. Follow me on Twitter at openargs, OPENARGS. Or you can search for Andrew Torrez with a Z, which will TORREZ, which will give you my law page for the law offices of P. Andrew Torrez. That's patorres.com. I'm pretty easy to find, and Thomas and I are pretty active in talking to folks. By the time this goes live, I am crossing my fingers. I am hopeful that the Opening Arguments podcast will be up and populated on iTunes. If it's not, complain to Callie. Send her email right now.
Yeah, and Andrew's complaint line is thegaytheistmanifesto@gmail.com.
And thank you very much for having me on the show. I really appreciate
this has been awesome. I've learned so much, and I feel much better equipped to have arguments with people. So this is good
I have a friend who's a lawyer, and he said this.
Right,
so
that's wrong. Exactly it. Well, that, my friends, is going to do it for this episode of the Gaytheist Manifesto on Secular Media Network. Definitely want to thank Andrew again for all of his time and all of his insights. I hope we all learned a whole lot. You can find the show on Facebook at facebook.com/The Gaytheist Manifesto. You can email us at thegaytheistmanifesto@gmail.com. I'm on Twitter at GaytheistCallie. You can find the show on Twitter at The Gaytheist, and Ari's stupid outro's next.
What did you just say about me, you little bitch? I'll have you know, I graduated top of my class in religious studies at Vassar College, and I've been involved in numerous acts of protest against religion's influence in government, and I have over 300 confirmed deconversions. I'm trained in street epistemology, and I'm the top activist in the entire atheist movement. You're nothing to me but just another religious sheep. I will wipe your ideology out with precision the likes of which has never been seen before on this earth, mark my words. You think you can get away with saying that shit to me on my Ari Stillman Facebook page and my email at aristillman4@gmail.com? Think again. As we speak, I'm contacting my secret network of heathen spies across the USA, so you better prepare for the storm, maggot. The storm that wipes out the pathetic little thing you call your argument. I can be anywhere, anytime, including on a spin-off podcast with Jeremiah Traeger called SJW Circle Jerk, and I can convince you in over 700 ways. Not only am I extensively trained in formal debate, but I have access to the entire arsenal of Wikipedia pages on logical fallacies, and I will use it to its full extent to wipe your miserable religion off the face of the continent. If only you could have known what unholy retribution your little clever comment was about to bring down upon you, maybe you would have held your tongue. But you couldn't, you didn't, and now you're paying the price. I will rain intellectual fury all over you, and your so-called evidence will drown in it. Your dogma is dead, kiddo.
Wow, I feel very vulnerable and hurt right now.
I think my favorite outros are when I just take memes and just adapt them to be relevant to the show.
That's perfect.
That was awesome, hearing that outro live. Like, that was just spectacular.
If you want to support the show and the activism we do, you can head to patreon.com/thegaytheistmanifesto and make a per episode donation as little as $1 per episode. You can also head over and give us a 5-star review on iTunes. That means a lot as well. Before we go, I want you to know that if you're lost, you're hurting, you're scared, if you feel like no one cares and no one understands, you need to know there's a community out here that loves you, cares for you, knows that you're capable of amazing things and that you are worthy of love. If you're struggling, please don't be afraid to reach out. Until next time, friends, this is the Gay Theist Manifesto.